Picture this. A woman in Ohio loses her father. He did everything he thought was right. He had a will. It was signed. It was notarized. It was sitting in a drawer in his home office, exactly where he told her it would be. She thinks the hard part is over. The paperwork, she assumes, will be simple. What she doesn't know yet is that having a will doesn't mean skipping probate. It means probate now has instructions to follow. And over the next 14 months, she will watch nearly 6% of her father's estate, money that was supposed to go to her and her two brothers, disappear into court fees, executor commissions, attorney costs, and appraisal charges. Nobody warned her. Nobody sat her down and said, "Here's what this is actually going to cost you, and here's how long it's actually going to take." She found out the hard way, the way most families do. Here's the thing that surprises almost everyone the first time they hear it. Probate doesn't cost the same amount everywhere in this country. Not even close. Depending on which state your loved one lived in, and depending on how their assets were titled, probate can cost your family 2% of the estate, or it can cost 15%. It can wrap up in 3 months, or it can drag on for 2 years. And the wild part is, most people don't find any of this out until they're already living it, grief-stricken, exhausted, and staring down a stack of forms they never expected to see. Before we go any further, let's be really clear about what this video is and what it isn't. I'm an educator. I'm not an attorney. I'm not a financial advisor. And nothing in this video is meant to be legal advice for your specific situation. Estate and probate law is set at the state level, which is exactly why the numbers vary so much from place to place, and it can even vary by county within the same state. What I'm going to do today is walk you through how probate costs generally work, why some states are so much more expensive than others, and what tends to drive those costs up or down. But when it comes to your family, your assets, and your state's specific rules, you need to sit down with a licensed estate planning attorney where you live. Think of this video as the conversation that prepares you to have that meeting, not as a replacement for it. Why does this matter right now, today, whether or not anyone in your life has passed away recently? Because probate costs are one of those things that quietly erode an inheritance without anyone noticing until it's too late to do anything about it. If you're in your 50s, 60s, or 70s, there's a good chance you're either going to inherit something from your parents, or you're going to leave something behind for your own kids. Either way, probate is probably going to touch your life at some point, and knowing what's coming can be the difference between a smooth transition and a financial gut punch during an already painful time. So here's what we're going to cover together. First, I'll break down exactly what makes up the cost of probate, because it's not just one fee, it's a whole collection of them stacking on top of each other. Then, we'll look at why certain states are notorious for expensive, slow probate, and why others are known for being fast and cheap. We'll walk through a real-feeling illustrative example, so you can see the numbers in action, not just hear them in the abstract. And by the end, you'll walk away with a genuine checklist of things to look into for your own situation. If any of this feels useful to you, do me a favor and hit subscribe, because we cover exactly this kind of practical estate planning education every single week, and this channel exists to help you have smarter conversations with the professionals in your life. Let's start with what actually makes up the cost of probate, because when people hear a percentage like 6% or 10%, it sounds like one single bill. It's not. Probate costs are really a bundle of several separate expenses, and depending on your state, some of them are set by law, and some of them are negotiable. The first big piece is court filing fees. Every probate case has to be opened with the local probate court, and that requires a filing fee. In most states, this is a flat, relatively modest amount, often somewhere between $50 and a few $100s. This part is rarely what causes the sticker shock. The second piece, and this is where things start to diverge sharply between states, is executor and attorney compensation. Some states, and this is important, actually set statutory fees for the executor and the probate attorney based on a percentage of the estate's value. California is probably the most well-known example of this. California law sets out a fee schedule where the executor and the attorney can each collect a percentage of the estate, and those percentages are calculated on a sliding scale that actually gets smaller as the estate gets bigger. But even so, on a $500,000 estate, you could be looking at statutory fees for the executor and statutory fees for the attorney that combined run into the tens of thousands of dollars. Other states work completely differently. Many states simply require that fees be reasonable based on the actual work performed, which means the final cost depends heavily on the complexity of the estate and the hourly rates in that area, rather than a fixed percentage. The third piece is appraisal and valuation costs. If the estate includes real estate, a business, valuable collectibles, or anything else that doesn't have an obvious market price, the estate typically needs a professional appraisal, and sometimes more than one. These costs vary depending on what's being appraised and where you live, but they're rarely trivial, especially for real estate in high-value markets. The fourth piece is the cost of the surety bond. Some states require the executor to post a bond, essentially an insurance policy that protects the estate's beneficiaries in case the executor mismanages the assets. Not every state requires this, and a will can sometimes waive the bond requirement, but where it's required, it's another line item on the bill. And the fifth piece, which people almost never think about until they're in the middle of it, is time itself. Probate that drags on for 18 months or 2 years doesn't just cost more in professional fees, it also means beneficiaries are locked out of using or selling estate assets during that entire window. A house that's sitting empty during a long probate process still needs insurance, still needs property tax payments, still needs maintenance, and none of that stops just because the paperwork is slow. Now let's talk about why some states are dramatically more expensive than others, because this is really the heart of what shocks people. Broadly speaking, states fall into a few different camps. Some states, including California and a handful of others, use that statutory percentage-based fee structure I mentioned, and those percentage-based systems tend to produce the highest dollar costs, especially on larger estates, because the fee scales up right alongside the value of the home or the investment accounts involved. Other states have adopted what's called the Uniform Probate Code, a model law that a number of states have used as the basis for their own probate statutes, generally aiming for a more streamlined, less expensive process. States that have adopted a version of this uniform approach, places like Arizona and Colorado, are often cited as examples, tend to have simpler procedures, particularly for smaller estates, which can qualify for simplified or summary probate processes that skip much of the formal court involvement altogether. Then there's the question of how court-dependent a state's process is in the first place. Some states make it relatively easy to avoid formal probate through mechanisms like transfer on death deeds for real estate, payable on death designations for bank accounts, and small estate affidavits for modest estates under a certain dollar threshold. Where those tools are widely available and the thresholds are generous, families often sidestep the most expensive parts of probate entirely. In states where those tools are more limited, or the small estate thresholds are very low, more estates end up funneling through the full formal process, with all its associated costs. Let's make this concrete with an illustrative example, and I want to be clear, this is not a real family. It's a composite scenario built to show how these pieces interact. Imagine a couple, we'll call them the Whitfields, living in a state with a percentage-based statutory fee system. The husband passes away with an estate worth around $600,000, made up mostly of a paid-off house, a retirement account that unfortunately was never updated with a current beneficiary designation, and some savings. Because the retirement account lacked a valid beneficiary form, it gets pulled into the probate estate instead of passing directly to his wife the way it was supposed to. The statutory executor fee and the statutory attorney fee, calculated as percentages of that $600,000 estate, combine to somewhere around 4% of the total value. Add in appraisal costs for the house, a required bond premium, court filing fees, and the carrying costs of the property sitting through a 14-month process, and the family ends up losing close to $35,000 to expenses that a slightly different set of choices could have avoided almost entirely. Now imagine a second, different family. We'll call them the Alvarez family, living in a state with a simplified small estate process. And let's say the husband had, years earlier, retitled the house into a revocable living trust and made sure every account had an updated beneficiary designation. When he passes away, there is functionally no probate at all for those assets. The trust simply distributes according to its terms, and the accounts pass directly to the named beneficiaries. The difference between these two families isn't luck. It's almost entirely about which tools were used ahead of time and which state's rules applied. Let's get into the third core piece of this, which is timeline, because cost and time are deeply connected. Simple, uncontested probate cases in efficient states can sometimes wrap up in as little as 3 to 6 months. But the national reality is that the average probate case takes somewhere between 6 months and a year, and it's not unusual, especially with larger or more complicated estates, or estates that include real property in more than one state, for the process to stretch past 18 months or even 2 years. Contested wills, disputes among heirs, hard to locate beneficiaries, and complications from creditors all add time. And time, as we talked about, has its own cost attached to it. Now let's talk about the myths, because there are a few big ones that trip people up constantly. The first myth is that having a will means you avoid probate. It doesn't. A will is simply an instruction manual for the probate court to follow. If you want to avoid probate, the tools that actually do that are things like a properly funded revocable living trust, beneficiary designations, and transfer on death or payable on death registrations, not a will by itself. The second myth is that probate is only a concern for the wealthy. In reality, probate touches modest estates all the time, and in states without generous small estate exemptions, even a house and a checking account can trigger the full formal process. The third myth is that all states are roughly the same, which we've just spent this entire video disproving. The difference between the least expensive and most expensive states can be a difference of tens of thousands of dollars on an identical estate. And the fourth myth, maybe the most dangerous one, is the belief that you can just wait and figure all this out later. Estate planning tools like trusts and beneficiary designations only work if they're set up and properly maintained while the person is alive and of sound mind. Once someone has passed away, the options for avoiding probate on their estate are already locked in. So what should you actually do with all of this? Let's turn it into a practical checklist. Start by finding out how your state's probate system actually works, specifically whether your state uses statutory percentage fees or a reasonable fee standard, and whether your state has adopted a version of the Uniform Probate Code with simplified procedures. Next, take an honest inventory of how assets are currently titled, meaning whose name is on the house, whether retirement accounts and life insurance policies have up-to-date beneficiary designations, and whether any accounts have payable on death instructions attached. Look into whether your state offers transfer on death deeds for real estate, because in states that allow them, this is often one of the simplest and least expensive tools available. If your estate is more complex, ask a licensed estate planning attorney whether a revocable living trust makes sense for your specific situation, since a properly funded trust can bypass probate court entirely for the assets placed inside it. And finally, revisit these documents periodically, especially after major life events like a marriage, a divorce, the birth of a grandchild, or the death of a named beneficiary, because outdated paperwork is one of the most common and most avoidable reasons families end up paying more than they needed to. At the end of the day, this isn't really about percentages and statutes. It's about protecting the people you love from unnecessary stress during one of the hardest moments of their lives. Nobody wants their spouse or their kids standing in a courthouse hallway months after a funeral, watching a meaningful chunk of what was left behind quietly get eaten up by fees that could have been avoided with a little planning. The families who avoid this outcome aren't necessarily wealthier or smarter. They're just families where someone took the time, while there was still time to take, to understand how their state system actually works, and to put a few simple tools in place. That's really what this channel is about, giving you the plain English understanding you need, so that when you do sit down with a professional, you're asking the right questions, instead of hearing all of this for the very first time. If this video helped you understand something you'd never really thought about before, please consider subscribing, because we publish new videos on exactly this kind of practical, real-world estate planning education every week, and there's a good chance the next video answers the very next question you'd have asked. And one more time, because it matters, everything in this video is general education, not legal advice. Probate laws, fee structures, and available planning tools vary significantly from state to state, and sometimes even county to county. Before you make any decisions about your estate or a loved one's estate, please talk to a licensed estate planning attorney in your state, who can look at your actual situation and give you guidance that applies to you. Thanks so much for spending this time with me today, and I'll see you in the next video.